CIV3701 Civil Procedure Stage 1 Part 2 Pre-litigation issues. A. Demand. Number 1. What is a demand? A demand is a request for payment or a request for the performance of a legal obligation. A demand is made before legal proceedings start, as it is an attempt to obtain satisfaction without incurring the expense of formal litigation. The need to demand payment or performance is, of course, due to a failure to respond to informal requests for payment or performance. A valid demand may be made by a person, that is, the future plaintiff or applicant himself, or later by his attorney. Also, a demand need only be made once. It is not necessary to prove that repeated demands which were not complied with were made. The person sending the demand also has a legal obligation to take reasonable steps to ensure that the demand reaches the intended recipient. 2. Forms of demand. The demand for payment or performance can take many forms. It may be made orally, it may be made in writing in the form of a letter of demand, or demand may even be constituted by institution of legal action, that is, by the service of summons on a defendant or by launching an application against a respondent. Note that as the summons itself may constitute a legal demand, it need not be preceded by a letter of demand. A number of other forms of demand, such as sending a statement of account or invoice to the person allegedly in default, have also been recognized in our law. In such cases, however, the principle is that it must be clear to the recipient that a demand for payment or performance is in fact being made. In terms of certain statutes, it is a legal requirement to send a letter of demand, giving notice to the recipient that you intend taking legal action. In such cases, the letter of demand is also called a notice. Do not, however, confuse these notices with formal court notices, such as the notice of set down and the notice to discover, that are made in terms of the High Court or Magistrates' Court's rules. Where statutes require that notice be given before litigation commences, it means merely that the letters of demand sent must comply with the time restrictions and other requirements imposed by these statutes. Number 3. The contents of the demand. The general rule is that the demand, whichever form it takes, has to contain sufficient detail to inform the recipient of the whole cause of action. In the case of a letter of demand, for example, it means that the recipient must receive information covering all the elements of the alleged claim, for example, the 4 elements of a delictual Aquilian action. The recipient must be put in possession of all the information necessary to determine his liability so that he can decide whether to defend or settle the claim. In addition, the letter must contain a paragraph, sometimes called the demand clause, in which the actual demand for payment or performance is made, usually also indicating the time period within which payment or performance must occur, and the consequences of not complying with the demand. Always keep in mind, too, the possible evidentiary effect of the contents of the letter of demand. Should the matter go to trial, the letter of demand will be discovered in terms of the rules of court, and any discrepancies between the letter of demand and the particulars of the claim could be exploited in cross-examination. In some circumstances, it may not be necessary to spell out the elements of the cause of action in detail, as previous communications may provide the context for only a brief demand for payment or performance. In some cases, it may not be necessary to deliver a demand at all. In the next section, we consider the situations where demand is always necessary. Number 4. Circumstances where demand must be made. A demand is always necessary in the following circumstances. First, where legislation requires that notice be given, or a letter of demand be delivered prior to litigation. And secondly, where demand must be made to complete a course of action. 4.1. Demand or notice required by statute. The most important statutes requiring that demand be given prior to the institution of litigation or the institution of legal proceedings against certain organs of State Act 40 of 2002. Also, the General Law Amendment Act 62 of 1955. Also, the Customs and Excise Act 91 of 1964. Also, the National Credit Act 34 of 2005. Also, the Small Claims Court Act 61 of 1984. And the Road Accident Fund Act 56 of 1996. The institution of legal proceedings against certain organs of State Act 40 of 2002 will now be considered in some detail, followed by a brief overview of some of the more important of the other statutes mentioned. 4.1.1 The institution of legal proceedings against certain organs of State Act 40 of 2002. The Act. This Act, which has been effective from the 28th of November 2002, consolidates the notice and time limit requirements contained in various other statutes that have to be complied with when initiating civil actions against various state organs. Any civil action brought against any national, provincial, or local government department, any institution exercising a function in terms of the Constitution, the South African Maritime Safety Authority, the South African National Roads Agency Limited, or even any person for whose debt an organ of state is liable, must comply with the provisions of the Act. In terms of Part 2 of the Act, no legal proceedings for the recovery of a debt may be instituted against an organ of state unless the creditor has given the organ of state notice in writing of the intention to institute legal proceedings, or the organ of state has consented in writing to the institution of those proceedings. In terms of Section 3, subsection 2b of the note, the notice must briefly set out the facts giving rise to the debt, and the particulars of the debt, for example, the amount, the parties involved, the date incurred, etc., that are within the knowledge of the creditor. These requirements, in effect, make the notice a letter of demand. The notice must be served on the organ of state concerned within 6 months from the date on which the debt became due. The various methods of service of the notice are contained in Section 4 of the Act, which even allows for the service of the notice by electronic mail. By contrast, the methods of service of court process for the purposes of this Act are contained in Section 5. No court process may be served on an organ of state concerned before the expiry of a period of 30 days after the date on which the notice was served on that organ of state. If any court process is served on an organ of state before the expiry of the 30-day period, the process will be regarded as having been served on the first day after the expiry of the 30-day period. Service before the expiry of the period will therefore not interrupt prescription. For example, an action against the National Police Force, the SAPS, will have to be preceded by the drafting of a notice in terms of Section 3 of the Act, and served on the Department of Safety and Security in terms of Section 4, subsection 1a. Subsequent service of process, that is, court documents, as opposed to the notice which is a letter of demand preceding court action, must take place in terms of Section 5, subsection 1b2 of the Act, which permits process to be served on the National Commissioner of the SAPS or a Provincial Commissioner of the SAPS, instead of on the Minister of Safety and Security, who would be the usual nominal defendant in terms of Section 2 of the State Liability Act 20 of 1957. However, should the proposed legal claim arise from the actions of a Metropolitan Police official employed by, say, eThekwini municipality, notice may be given to the municipal manager of the municipality. Although the notice provisions in the statutes listed in the schedule of to the Act have been repealed or amended by Section 2, subsection 1 of the Act, there are a number of statutes that have not been included in this schedule. The specific notice provisions contained in these unrepealed and unamended statutes must be applied in these cases, and not the uniform notice and service provisions contained in Part 2 of the Institution of Legal Proceedings Against Certain Organs of State Act 40 of 2002. Note that if an organ of state relies on a creditor's failure to serve a notice in terms of Section 3, subsection 2a of the Act, the creditor may apply to the court for condonation. 4.1.2 Interim Interdicts against the Government. The General Law Amendment Act 62 of 1955. Section 35 of this Act provides that no court is permitted to issue a rule nisi that operates as an interdict against any branch of national or provincial government, or any official as defined in the Act, unless notice of the intention to apply for such a rule is served on the defendant concerned at least 72 hours before the hearing of the application. 4.1.3 The Customs and Excise Act 91 of 1964. In terms of Section 96 of this Act, legal action must be taken against the department within 1 year of the debt becoming due, or the cause of action arising, and written notice of the intention to institute legal proceedings must be given at least 1 month before the legal proceedings are actually instituted. 4.1.4 The National Credit Act 34 of 2005. This Act, which came into force on the 1st of June 2007, specifies various legal requirements that have to be complied with relating to the giving of notice and the commencement of legal proceedings to enforce a credit agreement to which the Act applies. For example, a credit provider may not commence legal action against a consumer before first giving notice to the consumer in terms of Section 129A or Section 86, subsection 10 of the Act, and then only after having complied with other requirements contained in Section 130 of the same Act. Note that some High Court divisions' practice manuals require a certificate to be attached to a summons commencing action for a debt indicating compliance with the provisions of Section 129. The impact of the National Credit Act 34 of 2005 on civil procedure generally is discussed in Annexure B. 4.1.5 The Small Claims Court Act 61 of 1984. Section 29 of the Small Claims Court Act 61 of 1984 provides that a letter of demand must be delivered by the plaintiff to the defendant by hand or registered post before legal action may be taken. Section 29 further provides that a period of 14 days must elapse after receipt of this letter by the defendant before the Small Claims Court summons may be issued. 4.2 Demand essential to complete a cause of action. Here, unlike the section above, where the making of a demand was a statutory precondition to commencing legal proceedings, the making of a demand for payment or performance is required as it forms part of the cause of action. For example, the parties to a contract may agree in the written contract that a cause of action will not arise for a breach of a term of that contract until a demand has been sent. Let us look at some examples of where the making of a demand is required as part of the cause of action. 4.2.1 Payable on demand. Many contracts contain a clause which states that a certain amount is payable on demand. Until the amount has been demanded, it is not due and payable, and no cause of action will arise for failure to pay the amount. Demand is thus necessary to complete one's cause of action. 4.2.2 Notice of breach clauses. Certain contracts contain a stipulation to the effect that the parties to the contract are not permitted to commence action for breach of a term of the contract unless the party who intends to commence action has given written notice of his intention to do so. No cause of action will arise until such notice has been sent. 4.2.3 Placing a debtor in mora. In some cases, the contract between the parties may not stipulate a specific time for performance of an obligation, or it may not be clear from the terms of the contract exactly when performance is due. In such cases, performance must be demanded and a reasonable time for the performance of the contract is given. For a cause of action to be established, for example, where a debtor has failed to pay an account that was delivered to him for goods sold, you will have to send the debtor a letter of demand in which he is given a stipulated time period in which to pay. If the debtor then does not pay after the expiry of the stipulated time period, he will be in mora from the date on which the period expires. Mora, interest on the debt, then begins to run from this date. The Prescribed Rate of Interest Act 55 of 1975 was amended in 2016 and now provides that the prescribed rate of interest, which was previously a fixed rate, is to be determined with reference to the repurchase rate, that is, repurchase rate plus 3.5%. In order to be certain as to the prescribed rate, practitioners should always consult the notice published by the Minister of Justice and Correctional Services in the Government Gazette. The Minister will publish the amended rate in a notice whenever the repurchase rate is adjusted. 4.2.4 Demand to give right of cancellation. If the contract is clear on the date of performance, or it is clear from the nature of the contract precisely when performance is due, for example, a contract to bake a cake for a wedding which is due to take place on a certain date, and there is no express stipulation in the contract that a specific form of demand is required before action is commenced, it is not necessary to send a letter of demand. However, where the date of performance is not clear or where an agreement does not contain a cancellation clause, you will have to send a letter of demand in which payment or performance of the obligation within a stipulated reasonable time is demanded. Should the recipient not comply with this demand, a further letter cancelling the agreement can be sent on the expiry of the stipulated time period, or the agreement can be cancelled in the particulars of claim attached to the summons. Note that where an agreement does contain a cancellation clause, it may nevertheless be prudent to send a letter of demand as cancellation without demand may be construed by the court to have been unreasonable. The court may then decide not to award you the costs of issuing and serving of the summons. Number 5. Other consequences of demand, that is, costs and interest. The decision whether or not to deliver a demand for payment or performance prior to the institution of legal action may also affect the interest on the debt that may be claimed, and the legal costs that may be recovered. 5.1. Costs relating to the issue of summons. Should the plaintiff decide to issue summons without first delivering a letter of demand to the defendant, he may incur unnecessary costs in two ways. In the first place, the defendant may very well have paid on receipt of the demand, thereby saving the plaintiff the costs of issuing and serving the summons, that is, the payments the plaintiff would have to make to his own attorney for issuing and serving the summons. Secondly, the defendant could argue that he would have paid had he received a letter of demand prior to the summons, and the court may then refuse to allow the plaintiff to recover the costs of the summons. The danger of a cost order against the plaintiff in these circumstances is heightened if the debt was an unliquidated debt, as the defendant could argue that he was not aware of the exact amount payable until a demand had been received. Note that in terms of Section 56 of the Magistrates Courts Act 32 of 1944, a creditor may only recover the costs of a letter of demand if it is sent by registered post. The situation might well be different in the case of a liquidated debt, which is due for payment. In cases where the debtor knows that payment is due, as well as the amount that he has to pay, the creditor is clearly well within his rights to proceed directly to the issue of summons without sending a letter of demand. Even if the debtor pays the amount due immediately after he receives the summons, the creditor will probably be entitled to the costs of the summons since the debt was due and payable before the summons was issued. The guiding principle seems to be that the court will consider whether the failure to deliver a letter of demand was reasonable in the circumstances or not. 5.2. Unliquidated debts. Delivering demand to start the running of interest. If your action is to recover an unliquidated debt, for example, a delictual claim for damages, the delivery of a letter of demand or summons to the debtor is sufficient to start the running of interest. It is quicker and easier to draft and deliver a letter of demand than to draft, issue, and serve a summons. Therefore, as a general rule, it makes sense always to send a letter of demand before drafting particulars of claim and preparing summons. CIV3701 Stage 1 Part 2 Pre-litigation issues. B. Calculation of time limits. Number 1. Introduction. Throughout this book, you are going to be dealing with the time periods within which various steps have to be taken. Calculating these time periods may prove difficult. For example, if a lecturer asks a student to hand him a 20-page essay within 5 days, what does that mean? Does the 5-day period include the day on which the lecturer makes the request, or does the period start running the day after the request is made? What happens if the last day of the 5-day period happens to be a Sunday? Does it mean that the student has to show up at the university with the essay regardless of the fact that all the buildings will be locked and most of the staff will be at home? Similar problems relate to the calculation of time periods mentioned in the High Courts and Magistrates Courts Acts and Rules. Number 2. Time periods within a certain period. Most of the time periods mentioned in the High Court and Magistrates Courts Acts and Rules require things to be done within a certain period. 2.1. FOLI. First out, last in. The first point to note is that when a section or rule requires something to be done within a certain period, you exclude the first day and include the last day. Remember the acronym FOLI, which stands for First Out, Last In, or FOLI. Using the student's essays example, what this means is that if you are told today that you must hand in an essay within 5 days, then the 5-day period starts running tomorrow and ends at the end of the last day of that 5-day period. In other words, 2.2. Court days and calendar days. The FOLI rule does not solve all your problems because certain days must be excluded from, that is, not counted as part of, the 5-day period reflected in the example above. Precisely which days must be excluded from the 5-day period will depend on whether you are dealing with periods stipulated in the Acts or the rules. When the Acts refer to days, the reference is normal calendar days. But when the rules refer to days, the reference is to court days. When, for example, the Superior Courts Act 10 of 2013 refers to 5 days, it means 5 calendar days. But when you see the same reference to 5 days in one of the High Court rules, it means 5 court days. Calendar days include Saturdays, Sundays, and public holidays. In other words, even if any of days 2, 3, 4, or 5, or 6, that, for example, the 5-day period in the above example were a Saturday, Sunday, or public holiday, they would still be counted as part of the 5-day period. However, if the last day of a period of calendar days, that is, day 6 in the above example, happens to fall on a Sunday or public holiday, then that day is not counted as part of the period. The period will end on the next day. Court days do not include Saturdays, Sundays, or public holidays. In other words, if any one of days 2, 3, 4, or 5, or 6 were on a Saturday, Sunday, or public holiday, then that day will not be counted as part of the 5-day period, and the period will only end after 5 full working days have passed. Number 3. Time periods after a certain period. Sometimes a section or rule provides that something may only be done after the lapse of a certain period. For example, if you were told that you had to hand in a 20-page essay after 5 days had elapsed, exactly when would you have to hand in your essay? In this case, you would exclude both the first and last day of the 5-day period. In other words, you would have to hand it in on the 7th day. Whether or not you should exclude Saturdays, Sundays, or public holidays from the 5-day period indicated above would, of course, depend upon whether you were dealing with court days or calendar days. Number 4. A practical note. Service of court process. There is one further factor that you must bear in mind when it comes to time limits. Although a particular time period only expires at midnight on the final day, as calculated in terms of the calculation rules in paragraphs 2 and 3 above, you must remember that many time periods relate to the time within which legal documents are to be served. It is futile to have your document ready at 1 minute to midnight on the final day of a particular time period, but not be able to serve the document at that hour. If you have to serve the document on a business, ensure that the document is ready for service before the close of business on the final day of the time period allowed. Also keep in mind court operating hours. CIV3701 Civil Procedure Stage 1, Part 2, Pre-litigation issues. C. Serving of legal documents. Number 1. Introduction. In most cases, legal proceedings are started with the delivery of court documents, also called court process, to the defendant or respondent. This delivery is called the service of these documents. The fundamental rule is that the court must be satisfied that the defendant or respondent has received these documents, that is, the summons or notice of motion, depending on whether an action or application is being brought, which starts the legal proceedings, and is therefore aware that legal proceedings are being brought against him. This is because of the legal maxim odi alterum partem, which literally translated means hear the other side. It means that every person is entitled to be heard before an order or judgment is granted against him. This explains why our courts meticulously enforce the requirement that an opponent should be notified timeously of the steps taken against him, and that he should be given an opportunity of replying to the case stated against him, and of placing his own version before the court. The documents which start legal proceedings, that is, the court process, must be served by an independent official who is called the sheriff of the court. In the High Court, court process is served by the sheriff on the High Court, and in the regional and district magistrates' courts by the sheriff of the magistrates' courts. In the past, the sheriff of the magistrates' courts was known as the messenger of the court, and you may still encounter this term in order writings and case reports. In terms of Section 3 of the Sheriffs Act 90 of 1986, a sheriff is appointed to serve documents within a particular area and may not serve outside the area for which he was appointed. The Greater Durban area, for example, has been divided into 3 sub-areas: Durban Central, Durban North, and Durban South. If you want to serve a summons on a firm situated in the center of Durban, you have to use the sheriff for Durban Central, and may not use the sheriffs appointed for the other two areas. Should you mistakenly send this summons to, say, the sheriff for Durban North, he will simply send it back to you and tell you that the service address falls outside his area of operation. Full details of the different sheriffs and the areas they serve are listed in the Waters Legal Diaries or on the South African Board of Sheriffs website. Number 2. The issue of process and duties of the sheriff. Before you are legally permitted to serve a court document, it must be issued. Historically, the issuing procedure involved the attorney sticking revenue stamps on the top right-hand corner of the relevant court document and sending it to the court where the revenue stamps were date-stamped and cancelled, and the document signed. Following the demonetization of revenue stamps, the entire Rule 67 of the High Court Rules establishing the tariff of court fees was suspended with effect from the 1st of April 2009. Therefore, revenue stamps are no longer used. Documents that initiate legal proceedings, such as a summons or notice of motion, are given a case number, that is, a consecutive number for the year during which it is filed, and a court file is opened. Note that after issuing the document, it is discovered that if, after issuing the document, it is discovered that the address was wrong, it is necessary to amend the document, sign the amendments, and then send the document back to the court where the registrar or clerk of the court, as the case may be, will review the document by signing the amendments. After being issued, the following documents will be sent to the sheriff for service. First, the original document, which will be returned to the court file. Secondly, the number of copies of the document which need to be served. For example, if there are 3 defendants, then you will need 3 copies for service. And lastly, an extra copy of the document, which will be returned to you to place on your office file. The sheriff has various duties he must perform when serving court process. First, he must explain the nature and contents of the document to the person being served, and state in return that he has done so. Secondly, the sheriff must then hand a copy of the document to that person. If the document is a summons or a notice of motion, the sheriff must warn the defendant or respondent of the consequences of failing to defend the action or oppose the application. Also, if requested to do so, the sheriff must show the original or a certified copy of the document to the person being served. The purpose of this is to allow the person to compare the original with the copy of the document being served on him. And third, the extra copy of the document will be returned to the attorney who requested that the service be carried out, together with the sheriff's return of service. A return of service is a written report from the sheriff stating when, where, and how he served the document. The return of service constitutes prima facie proof of service. It is therefore essential to always check that the return has been properly signed by the relevant sheriff. Where the sheriff is unable to successfully serve a summons or notice of motion in terms of the rules, he completes what is called a return of non-service. Note that not all court process has to be served by the sheriff or his deputies. A number of court documents that follow the initial summons, such as a notice of intention to defend, a plea, or a replication, need not be served by the sheriff. In these cases, it is sufficient to deliver the documents to the service address indicated on the initial summons or notice of motion, either yourself or by means of a messenger employed by your law firm. The indicated address will usually be the address of the firm of attorneys acting for your opponent. That firm will stamp the original and 2 copies of any document delivered to them as follows: received without prejudice. The original and 1 copy will be returned to you. You will keep the copy in your office file so that you can prove that the other side has received the document, and file the original with the registrar or clerk of the court, who will place it in the court file. Rule 4a provides that all process, other than process which initiates application proceedings, may be served by hand at the physical address for service provided, registered post to the postal address provided, or facsimile or electronic mail to the respective address provided. Rule 4a explicitly provides that service under this rule need not be effected through the sheriff. Furthermore, the court documents which initiate interlocutory applications, for example, an application to compel the other side to discover, need not be served by the sheriff. The reason is that an interlocutory application is an application which is part of proceedings that are already pending before the court, and addresses for the service of these documents are already indicated in the documents relating to those pending proceedings. In other words, it is usually only the initial court documents in legal proceedings which are served by the sheriff. Number 3. Methods of service in terms of the rules of court. In this section, we consider the usual methods of service available in terms of the Magistrates' Court's rules and High Court rules, followed by a consideration of specialized forms of service, such as edictal, citation, substituted service, and service outside of South Africa's borders. 3.1. The usual methods of service in the High Court. The different methods of service in the High Court are set out in Rule 4, subsection 1a of the High Court rules. First, personal service. Personal service should be used whenever possible, and the other methods of service provided for in the rules should only be used where the defendant or respondent is elusive or untraceable. Here the court process is delivered to the person personally, by which it is meant that the sheriff is actually in the defendant or respondent's presence and hands the relevant document to him. Where the person to be served is a child that is younger than 18 years or is under some form of legal disability, the process must be delivered to that person's guardian or tutor or curator, as the case may be. The High Court rules do not provide for any instances where personal service is the only method of service permitted. But the judges of the various high courts have used their discretionary power to make it a rule of practice that personal service is required in certain matters, such as in divorce proceedings, sequestration proceedings, and cases where the attorney wishes to withdraw as the attorney of record. In cases where personal service is required but not possible, application must be made for discretions from the court as to substituted service, in terms of Rule 4, subsection 2. If the person to be served refuses to accept the document, it may simply be dropped at his feet. Secondly, leaving a copy at the place of residence or business. With this type of service, the documents may be left with a person at the place of residence or business of the defendant or respondent, provided that the person is apparently in charge of the premises and is apparently not younger than 16 years old. Both these requirements must be satisfied for the service to be effective. As far as the place of residence of the person to be served is concerned, if that person resides in a hotel, boarding house, or similar residential building, service on the manager of the hotel or boarding house or hostel will be sufficient. However, in the case of other types of residential buildings, for example, a block of flats which are occupied by more than one person or family, service must be effected in that portion of the building occupied by the person to be served. For example, if the person to be served resides in a block of flats, it will not be sufficient to serve the document concerned on the caretaker of that block of flats. It must be served on an occupant of the flat in which the defendant or respondent resides. If a person has more than one place of business or more than one residence, service may be made at any one of these. In the case of Cohen and another versus Lynch and another, the issue was whether a notice of cancellation affixed to the outside gates of a gated townhouse complex constituted delivery. In circumstances where the chosen domicilium was a specific unit in the complex, the court held that the chosen domicilium was the specific unit in the complex and not the complex itself, and the fact that access could not be gained to the chosen domicilium did not entitle the sellers to choose an alternative place for delivery. As far as the place of business of the person to be served is concerned, this refers to the place where that person conducts his own business, that is, if the person is self-employed, as opposed to the place where he is employed by someone else. Number 3. Service at the place of employment of the person to be served. Here, service is effected by delivering the document to a person who is apparently in authority over the person to be served, and is apparently not younger than 16 years old. Both these requirements must be satisfied for the service to be effective. Fourth, service at the domicilium citandi et executandi of the person to be served. A person's domicilium citandi is an address which has been chosen by that person for service of documents upon him. Many contracts contain a clause appointing a domicilium citandi, and you will usually find the term domicilium citandi et executandi used, which means the address for the purposes of service, citandi, and execution, executandi. Once a person chooses a domicilium citandi, service at that place will usually be good, despite the fact that the person to be served no longer resides there, has abandoned the property, or is not known at that address, or even if it is a vacant piece of land. Service must be effected strictly in accordance with the relevant domicilium clause. The purpose of domicilium addresses is that the parties should not be required to search for one another's whereabouts when wishing to litigate. In some cases, however, the use of domicilium addresses has been abused. For example, certain commercial enterprises have been known to include their own addresses in standard form contracts as being the domicilium citandi of one of the other contracting party. Should the other party then be sued following an alleged breach of contract, the summons on the defendant would be delivered to the plaintiff's address, and the first time the defendant would find out that the legal proceedings had commenced against him would be after default judgment had been granted. Such misuses of the domicilium addresses have led the courts to treat these addresses with caution, with the appellate division eventually deciding that courts have a discretion whether or not to accept domicilium addresses. As a general rule, the courts are reluctant to allow the use of domicilium address when the plaintiff is aware that the defendant is unlikely to receive notice of the proceedings if the domicilium address is used. An example of this would be when a bank is foreclosing on a mortgage bond and the defendant has already departed from the mortgaged property that is also the domicilium address. Note that the plaintiff is not obliged to serve at the domicilium address. He can choose to use any of the service methods provided for in the rules. Fifth, service on a company or a closed corporation. If you want to serve court documents on a company or closed corporation, you may serve the process at its registered office, or at its principal office of business within the court's jurisdiction, or in any manner provided by law. Service has to be effected by handing the process to a responsible employee, or if one of the employees wants to accept service, by affixing the document to the main door of the registered office or principal place of business. Note that the term principal place of business has a different meaning in the context of service than it does in the context of jurisdiction. In the context of jurisdiction, a company or closed corporation is said to reside at its principal place of business, which has been interpreted to mean the place at which the main management and control of the company or closed corporation are situated. In the context of service, however, principal place of business is interpreted to mean the chief place of business of that company or closed corporation which is situated within the area of jurisdiction of the court. If the company or closed corporation does not have a place of business within the area of jurisdiction of that court, the only option will be to serve summons at the registered office of that company or closed corporation. Number 6. Service on an agent duly authorized in writing to accept service. The agent must produce a written authorization to accept service of the process. Number 7. Service on a partnership, firm, or voluntary association. In these cases, the process may be left at the place of business of the partnership, firm, or voluntary association with the person who is apparently in charge of the premises, and is apparently over 16 years old. If there is no place of business, then the process may be served on a partner of the partnership, or the proprietor of the firm, or the chairman or secretary of the managing body of the association. Remember that in the case of a partnership, this only applies if you are acting against the partnership as such. If you are acting against partners in their individual capacities, the process will have to be served on each partner, using one of the methods laid down in the rules. Number 8. Service on a local authority or a statutory body. In the case of local authorities, including municipalities, process must be delivered to the town clerk or city manager or mayor of the local authority. In the case of statutory bodies, service may be effected by delivering the process to the secretary or to a member of the board of the statutory body. Number 9. Service on two or more persons being sued in their joint representative capacity. Here, service must be effected on each of these persons individually. Number 10. Service in legal proceedings against the state, a province, or a minister or deputy minister in his or her official capacity. In such cases, the process may be served at the office of the state attorney situated in the area of jurisdiction of the court out of which the process was issued. The office of the State Attorney of KwaZulu-Natal, for example, is situated in the MetLife building at 391 Anton Lembede Street, Durban. This information can be easily gleaned from the Department of Justice and Constitutional Development's website and should be checked regularly for any changes. 11. Service on prisoners. In these cases, the process may be served on the inmate personally. The official of correctional services who is in charge of the prison in which the inmate is detained must assist to facilitate the service of the process upon the inmate personally. 12. Service on foreign diplomats. See the case of Portion 20 of Plot 15 Atoll Proprietary Limited versus Rodriguez 2001. In terms of the High Court Rule for subsection 1b, service must be effected as near as possible between 7 o'clock in the morning and 7 o'clock at night. And in terms of Rule 4 subsection 1c, service may not be effected on a Sunday unless the court or a judge gives permission. The only exception to this rule is that a warrant of arrest may be validly served on a Sunday. Section 44, subsection 1a of the Superior Courts Act 10 of 2013 also provides for the service of process of courts by means of fax or any other electronic medium as provided by the rules. However, the High Court rules do not, as yet, provide for such means of service, and we anticipate that these rules will be amended to give effect to this provision of the Superior Courts Act in due course. In any matter, the court has a judicial discretion to determine, based on the facts, whether service was effective. If the court takes the view that service was defective, it may order the process to be served again. As noted earlier, the sheriff has a duty to explain the nature and contents of the documents to the person on whom he serves the document, and he has to record that he has done so on his return of service. 3.2. The methods of service in the regional and district magistrates' courts. The methods of service in regional and district magistrates' courts matters are set out in Rule 9 of the Magistrates' Courts Rules, which, in minor variations, is a duplicate of the corresponding High Court rule. The comments made in respect of the High Court rules generally apply to the equivalent Magistrates' Courts rules as well. A summary of the various methods of service follows. First, personal service. In terms of Rule 9, subsection 3a, as in the case of the High Court, personal service makes a provision for service on a guardian, tutor, or curator when the person is a child, or under some form of disability. Note also that any process through which a divorce action or action for nullity of marriage is instituted requires personal service in a regional magistrate's court. 2. Service upon a duly authorized agent. This also takes place in terms of Rule 9, subsection 3a. Number 3. Service at the residence or place of business of the defendant in terms of Rule 9, subsection 3b. The person served must be apparently 16 years or older. Number 4. Service at the defendant's place of employment in terms of Rule 9, subsection 3c. Note that a person apparently in charge of the defendant's place of employment need not be a person who is also apparently in authority over the defendant. For example, one of the defendant's co-workers may be in charge of the premises when the sheriff arrives to effect service, but does not have any authority over the defendant. Service on such person would be permissible in a regional or district magistrate's courts matter, but not in a high court matter. In high court matters, service must be effected on a person, apparently in authority over the defendant. In terms of a proviso to Magistrates' Court Rule 9, subsection 3, the court or the clerk of the court may treat service at the defendant's place of employment as invalid if there is reason to doubt whether the process served has come to the actual knowledge of the person served. And fifth, service at the defendant's domicilium certandi in terms of Rule 9, subsection 3d. The sheriff may serve at the defendant's domicilium certandi by delivering or leaving a copy at the chosen domicilium. Number 6. Service upon a corporation or company. In terms of Rule 9, subsection 1e, service may be effected on a corporation or a company either at its registered office or at its principal place of business, situated within the area of jurisdiction of the court concerned, on a responsible employee, or if they refuse to accept service, by affixing a copy to the main door. When the sheriff sends the process by registered mail, he must request that the addressee acknowledge receipt. If an acknowledgement is not received, the sheriff will mention this fact in his return of service. Although serving by means of registered post may seem to be an easy option, this is not necessarily the case. Many debtors do not collect registered post which is sent to them, and as stated above, the fact that there is no acknowledgement of receipt will be mentioned in the sheriff's return of service. The lack of an acknowledgement of receipt usually gives rise to doubt as to whether the document concerned has actually been received, and may result in the court treating the service as invalid. Rule 9, subsection 3 specifically provides that if process is served by registered post, where there is reason to doubt that the served process has come to the actual knowledge of the person on whom it was supposed to be served, and in the absence of satisfactory evidence, the court may treat such service as invalid. 7th, service upon state organs and state officials. Where the defendant is a state or provincial department or a minister, deputy minister, or premier in his official capacity, Rule 9, subsection 3G permits you to serve process on the national or local offices of the state attorney. Number 8. Service by affixing a copy of the document to the outer or principal door or security gate or placing a copy in the post box. Service in this way is allowed if the person who is going to be served with the process or document keeps his residence or business closed, thereby preventing the sheriff from serving the process upon him. In terms of Rule 9, subsection 5. Number 9. Service upon a partnership. In the case of a partnership, the sheriff may, in terms of Rule 9, subsection 7a, serve at the office or place of business of the partnership. If the partnership does not have an office or place of business, then the sheriff may serve upon any member of the partnership. Service on the member must be effected in any matter prescribed in Rule 9. Number 10. Service upon curators, executors, guardians, liquidators, and trustees. If 2 or more curators, executors, guardians, liquidators, or trustees of an insolvent estate are being summoned in their capacity as such, then service may be effected by serving on any one of them, as per Rule 9, subsection 7b. 11. Service upon clubs, societies, and similar bodies. In the case of a syndicate, unincorporated company, club, society, church, public institution, or public body, the sheriff may serve at the local office or place of business of that body. Otherwise, he may serve on the chairman or secretary or similar officer of the body, as per Rule 9, subsection 7c. Magistrates Court Rule 9, subsection 9a makes provision for service of any notice, request, statement, or other document which is not process of the court to be effected by hand delivery or by sending the document through registered post. Rule 9, subsection 9a further provides that such process may also be served by sending it by facsimile or electronic mail, provided the plaintiff has so requested and the defendant has consented thereto in writing. Where service is effected by facsimile or electronic mail, Chapter 3, Part 2 of the Electronic Communications and Transactions Act 25 of 2002 would be applicable to such service. Rule 9, subsection 14 provides for service in foreign countries. As a general rule, process, notices, and other documentation are not served on Sundays or public holidays. However, interdicts, warrants of arrest, and warrants of attachment of property may be executed on any day, at any hour, and at any place. But what happens if a document is improperly served on your client? Let us say the sheriff serves a summons on your client while he is enjoying his Sunday dinner. Does this mean that your client may simply ignore the summons? Unfortunately for your client, he cannot simply ignore the summons. Later in the book, we will be dealing with exceptions, which may be described as a form of legal objection to pleadings. Improper service is one of the grounds upon which one is entitled to accept to a summons. There is one final point to note. Section 107 of the Magistrates Courts Act makes it a criminal offence to obstruct a sheriff in the execution of his duties, dispose of goods attached by the sheriff, make a false declaration, fail or refuse to point out property you own, or refuse to neglect to deliver the title deeds of immovable property. Number 4. Substituted service and edictal citation. 4.1. Substituted service in general. If you have documents that need to be served, for example, a summons or notice of motion, and you are unable to serve by one of the usual methods of service, you will have to make an application to court for authority to serve these documents in some other way. This is known as an application for substituted service. The Magistrates Courts Rule 9, subsection 10, provides for substituted service, that is, service inside South Africa's borders, in the regional and district magistrates' courts, and reads as follows. Subject to Rule 10, where the court is satisfied that service cannot be effected in any manner prescribed in this rule and that the action is within its jurisdiction, it may make an order allowing service to be effected by the person and in the manner specified in such order. For edictal citation, that is, service outside South Africa's borders, Magistrates Court Rule 10 is relied on, which substantially replicates High Court Rule 5. This substituted service may be used only where the defendant or respondent is known or believed to be inside the country, and where service by one of the normal or required forms cannot be effected. While service on persons outside South Africa's borders must be effected by way of edictal citation in the district magistrates, regional magistrates, and high court. Note that it is only service of documents commencing legal process on persons outside South Africa's borders which must be effected by way of edictal citation. The reasons for your inability to serve the documents may vary from not knowing the whereabouts of the defendant or respondent to knowing the whereabouts but being unable to serve because the defendant or respondent refuses to open the door to the sheriff or is avoiding service in some other manner. You may suggest to the court whatever alternative method of service you like, as long as it is a common sense way to secure service in the particular circumstances. For example, if the defendant has disappeared but is known to be somewhere in the Durban area, you may suggest to the court that a shortened form of the document be published in a new newspaper circulating in the Durban area. If the defendant is avoiding service, you may request the court's permission to serve upon the defendant's relatives. The court will not grant an order substituting the usual method of service with another method suggested by you unless you have shown the court that you have already tried to locate the defendant but, despite your best efforts, are still unable to locate or serve on him. What this amounts to is that the allegations which must be contained in an application for substituted service are often precisely the same as those which would have to be contained in an application to serve by means of an edictal citation. It makes sense, therefore, to deal with these allegations in our discussion of the edictal citation application. 4.2. Service of legal process outside the country. 4.2.1. High Court, Regional and District Magistrates Courts. Application for edictal citation. In terms of Magistrates Courts Rule 10 or High Court Rule 5, if you want to serve documents instituting High Court proceedings outside the Republic, then you first have to make an application to court for leave to institute proceedings by means of an edictal citation. For example, if you want to institute an action in the KwaZulu-Natal Local Division in Durban against a defendant living in London, then you will first have to apply to that court for leave or permission to sue by means of an edictal citation. This is the case whether or not the defendant or respondent's address in the foreign country is known to you. If the precise address is unknown, then your application will be a dual one. In effect, A. To ask for leave to proceed by way of edictal citation, and B. To ask leave to use a method of substituted service. An edictal citation, also called an edict or citation, is merely a special type of summons, similar in almost every respect to a normal summons, except that it is addressed to the defendant directly, and not to the sheriff as is normally the case. This is because there may not be a sheriff, or similar officer serving legal process in the foreign country in which you wish to have the document served. Note that the need to apply to court for leave to sue by edictal citation only applies when you want to serve documents instituting legal proceedings in another country. If you want to serve any other kind of document in another country, then Magistrates Courts Rule 10, subsection 3 and High Courts Rule 5, subsection 3 applies, and it is not obligatory to make an application to court. You may simply request leave to do so at any hearing at which the court is dealing with the matter. Let us now consider the allegations you would have to include in the affidavit supporting your application. These are substantially the same allegations that would have to be made in application for substituted service. Number 1. The nature and extent of the claim. Number 2. The grounds upon which the claim is based. Number 3. The grounds upon which the court has jurisdiction to hear the claim. Number 4. The method of service you are asking the court to authorize. Number 5. The last known whereabouts of the person to be served. Number 6. The inquiries that have been made to find out where that person currently is. And lastly, any other information which may assist the court to make a decision. In relation to the manner of service which the court is being asked to authorize, the affidavit must set out a proposal for service and motivate why this particular method of service is being proposed. For example, you may state in the affidavit that the defendant is believed to be in the London area for a particular reason, that he used to read the Times newspaper regularly, and that therefore the publication of a shortened form of the summons in that newspaper should come to his notice. You will also attach the proposed shortened summons to the affidavit for the court's approval. In relation to the steps taken to establish the person's whereabouts, you have to satisfy the court that every reasonable step has been taken, but to no avail. Reasonable steps would usually include engaging tracing agents to do a search. A copy of their report indicating the lack of success would be annexed to the founding affidavits. Depending on the circumstances of the particular case, you may also include the following details in this regard. First, the defendant's last known place of residence. Secondly, the last place from which news of the defendant was obtained. Third, the defendant's last known domicile. Fourth, the residences of the defendant's spouse or partners, and other near relatives. Fifth, the defendant's place of birth. Number 6. Details of all the inquiries made to ascertain the defendant's present whereabouts. For example, first, his spouse or partner, parents, and relatives have been approached in order to ascertain his whereabouts, but to no avail. Secondly, his last known place of employment has been contacted, but they have no idea where he is. Third, the official sources such as the Department of Labor have no record of his present address. And lastly, tracing agents have been appointed but have been unable to trace him. And then, number 7. Details indicating that all possible sources of information about the defendant's whereabouts have been fully investigated and all necessary steps have been taken to locate the defendant. Finally, note that both an application for substituted service and an application to serve by edictal citation are brought ex parte. In other words, the applicant approaches the court alone, without the respondent having to be present, as these applications concern respondents who cannot be served with documents in the normal way because they cannot be traced or are out of the country. 4.2.2 Substituted service via electronic media. A court may order any manner of substituted service as is likely to bring the proceedings to the notice of the party to be served. The internet has brought a substantial shift in the way people communicate and how they access news and information. This has an ongoing and significant impact on the communication within the law. In 2008, an Australian court took the bold step of authorizing substituted service using Facebook, allowing service of a notice of default judgment on a defendant via Facebook. The same issue arose in the South African case of CMC Woodworking Machinery Proprietary Limited versus Pieter Odendaal Kitchens. In this instance, the KwaZulu-Natal High Court in Durban held inter alia that it was not unreasonable to expect the law to recognize and accommodate technological change, and this authorized substituted service of a notice of set down by way of a Facebook message addressed to the inbox of the defendant's Facebook page. In reaching its decision, the court examined several risks and pitfalls of such service. These included whether it constituted an invasion of privacy, whether the identity of the defendant could be established, whether the Facebook profile was genuinely that of the defendant and not a hoax profile, whether it complied with the Electronic Communication and Transactions Act 25 of 2002, whether there was any legal certainty of service, and whether proof of service could be provided. Although the court was, understandably enough, extremely cautious, ordering publication in a newspaper as well, it nevertheless concluded that service on the defendant's Facebook page was permissible as an alternative method when none of the prescribed methods were available, provided that certain factors were met. Apart from showing the usual factors required for why service in terms of the rules would not be possible, a court must also consider whether there is a reasonable certainty that the social media profile is indeed that of the party who needs to be served. Furthermore, that there is reasonable certainty that the party uses the social media network. That is, the court must be satisfied that the notice is likely to come to the party's attention, and that legal certainty of service would be achieved. Therefore, while the court may be open to new forms of service using electronic media, each case of substituted service using electronic media should be decided on its merits. The court must also take into account the type of document that is to be served. There are an increasing number of cases around the world in which similar approaches have been approved. For example, in Australia, the USA, Canada, the United Kingdom, while in South Africa, the KwaZulu-Natal Local Division, Durban, has also allowed service of a notice on a defendant's LinkedIn social media platform. Number 5. Jurisdiction and service distinguished. The High Court and Magistrates Court's rules regulating the service of court process cannot in any way be interpreted as conferring jurisdiction on a court. For instance, the domicilium addresses in a contract only appoint physical addresses for the purpose of the service of documents. The contract cannot be interpreted to hold that the court having jurisdiction over that area in which the domicilium address is situated will have jurisdiction in any dispute arising out of the contract. Similarly, with regard to High Court practice, although service at a defendant's place of work or employment is permissible in terms of High Court Rule 4, the court having jurisdiction over the area in which these places are situated will not have jurisdiction unless it is also the forum domicilii. That is, the court having jurisdiction over the area in which the defendant is domiciled or resident. For example, if a defendant were on holiday in a location that was not his place of residence, domicile, or even place of employment or business, which are additional grounds for jurisdiction in magistrates court's practice in terms of Section 28, subsection 1a of the Magistrates Courts Act, and a local sheriff was able to successfully serve a summons on the defendant personally, it would be a good service, but it would not give the local court jurisdiction to hear the matter. D. Action or application. Number 1. The decision. Action or application. In civil procedure, there are only two ways to litigate: by bringing an action or by launching an application. In the High Court, application procedure is provided for in High Court Rule 6 and by Magistrates Court Rule 55, which is substantially based on the High Court Rule 6, in the Regional and District Magistrates Courts. Once you have established that your client has, on the face of it, a legal remedy, you have to make a decision whether to enforce that remedy by way of an application, by way of action proceedings, or by way of application proceedings. The decision whether to proceed by way of action or application is crucial. If you proceed by way of application because it is quicker and cheaper, when by properly applying these criteria you should have proceeded by way of action, the court may dismiss the application with costs. Even if the court is lenient and does not dismiss the application outright but refers the matter to trial or orders that oral evidence be heard to decide the specific factual dispute, it will normally still make the failed applicant pay the wasted costs. We shall first consider the general differences between application and action proceedings, and thereafter briefly consider the criteria applicable when bringing High Court, Regional, and District Magistrates Courts applications. Number 2. Essential differences between actions and applications. 2.1. Actions. Action proceedings are characterized by a clear separation between the pleading stage and the trial and evidence stage. The pleadings consists of written statements made by and delivered between the parties, setting out the material facts on which the parties, that is, the plaintiff who initiates the action and the defendant who defends the action, rely in support of their claims or defense, as the case may be. It is important for you to note that only the material facts are set out in the pleadings. This means that the main allegations on which the claim is based are set out by the plaintiff, and the defendant sets out the main allegations on which the defense is based. The various kinds of evidence that may be relied upon to support these allegations will not be referred to at this stage. For this reason, except where a party is representing himself, he does not draft or sign the pleadings. This is done by the legal representative. Since the pleadings consist of simple statements of the material facts and do not disclose evidence, they are not affirmed under oath. Once the process of pleadings has been completed, the action is set down for trial, and at the trial the parties try to prove, by means of evidence, the allegations and responses contained in the pleadings. This is done through witnesses who appear in person and give evidence, or by handing in other evidence such as documents. The witnesses are examined in chief, cross-examined, and then re-examined. After the evidence has been completed, argument is addressed to the court by the parties, legal representatives, after which the court gives judgment. 2.2. Applications. In application proceedings, also called motion proceedings or just motions, the entire procedure is paper-based. That is, no leading of witnesses, and there is no separation between the pleading stage and this evidence stage. Here the evidence is not oral, but in writing, in the form of affidavits, that is, statements sworn under oath or affirmation. Further documents supporting the evidence contained in the affidavits may be attached to the affidavits as annexures. The affidavits with their annexures are then attached to the document that sets out the order sought from the court, that is, the notice of motion. So the affidavits not only set out the issues of fact between the parties, as would pleadings in an action, but also contain the evidence which the respective parties need to adduce in proof of their factual allegations. These factual allegations are also called averments. The result is that when the matter is set down for hearing, the court is already in possession of both the pleadings and the evidence. The hearing of an application, therefore, consists exclusively of legal argument by the legal representatives of the party, and it is only in exceptional cases that oral evidence is permitted. Number 3. The essential differences between trial courts and motion courts. Another difference between action and application proceedings is that they are heard in different types of courts. Action proceedings are heard in what are usually called trial courts. In a trial court, there is usually a raised bench where the judge or magistrate sits, and in front of this bench will be the tables at which the plaintiffs' and defendants' legal representatives sit. There will also be a witness box, usually set to the side of the judge's bench, from which witnesses will give evidence. Some trials might be over quite quickly, in a day or two, while others, which involve more complex issues, may last many weeks or even months. Application proceedings, however, are heard in what is known as the motion court. The motion court usually has a number of half-moon shaped tables in front of the bench to accommodate the larger number of practitioners who usually appear in a motion court on any given day. There are two main types of applications: opposed applications and unopposed applications. For unopposed applications, where there is no opposition presented in court against the applicant's notice of motion, there are usually a great many cases on the motion roll, and as each case only lasts a few minutes, many legal representatives appear in court simultaneously, some in more than one matter. One case after another is called, and one practitioner after another stands up, states his or her case, and then leaves the courtroom after the judge's decision. Sometimes an application is opposed. Here the respondent is at court ready to argue against the applicant. Opposed applications are set down separately for hearing, a few days in advance, and are heard after the unopposed matters have been dealt with. When the opposed application is finally called for hearing, both the applicant and respondent have to confine themselves to arguing only the issues in the documents before the court. That is, the issues on the papers. The opposed hearing therefore consists of the two parties' legal representatives presenting argument to the court on the evidence, which is set out in the application papers. These opposed matters resemble the closing argument stage that would normally take place at the end of a trial action. Remember that, in essence, the application procedure condenses the whole action process, as it requires the pleadings as well as the evidence to be contained in the application papers that are put before the court. The application procedure is therefore reserved for those matters in which the court is able to reach a decision on the documents put before it, without having to sit through a trial in which witnesses give evidence and are cross-examined. Applications are designed to deal with matters in which the oral evidence of various witnesses at a trial is not required because there is no real dispute between the parties about the facts of the case. Number 4. Making the choice: action or application. In all civil courts, you may now use application proceedings rather than action proceedings in urgent matters, where the application procedure is required by statute and where no real dispute of facts is anticipated. The leading case on the question is Room Hire Co. Proprietary Limited versus Jeppe Street Mansions Proprietary Limited, in which it was held that three possible situations exist. First, on the one hand, you have certain types of proceedings that must, in terms of statute, be brought by way of application. Examples would be an application to liquidate a company, or sequestrate a debtor, or rehabilitate an insolvent. Secondly, on the other hand, there are certain types of matters which the court is prohibited by statute from deciding on application. Examples would be an action for divorce or an action to recover damages which are unliquidated, that is, damages which are not fixed and which require evidence to establish their precise quantum or amount. And lastly, in between these two classes of cases, there is a grey area in which you must choose whether to proceed by way of action or application. The criterion which you must use to make this decision is whether or not there is any real dispute between the parties on any material question or fact. If there is such a dispute, then it is necessary to proceed by way of action in order to properly test and challenge the evidence. This is because it will be necessary for the parties to lead the evidence of witnesses, and for such witnesses to be cross-examined. For the court to decide whose version is the most is more probable. The court has to make a credibility finding after hearing and seeing the witnesses testify. This cannot be achieved merely by reading the prospective versions contained in the affidavits of the parties. This leads us to consider how to assess whether a real dispute of fact exists or not. Number 5. A real dispute of fact. Whether or not a real dispute of fact exists is not always easy to determine. Often the respondent has a weak case and is tempted to play for time, delaying matters by raising disputes of fact where no disputes actually exist. Remember that not all disputes of fact are real disputes of fact. It is easy for a respondent to take issue with arbitrary points in an applicant's affidavit and claim that a real dispute of fact exists. So when you are deciding whether to proceed by way of action or application, you must ask yourself whether or not it is likely that the respondent will be in a position to dispute the substance of what you are claiming in your application papers. Very few matters proceed without some sort of interchange and correspondence between the parties or their legal representatives before the matter is ready to begin. Usually, you should have at least some idea of your opponent's case as a result. If you are happy that your case is clear-cut and that the facts which are material to your case cannot be disputed, you may proceed by way of application. If there is no real dispute of fact and the respondent is just wasting time or being difficult, then the applicant should have nothing to fear. At the end of the day, the court will be satisfied if the application procedure was the correct procedure to use. In the room hire case, Murray pointed to a number of different ways in which a dispute of fact may arise. First, when the respondent denies all the material allegations made by the various deponents on the applicant's behalf and produces or will produce positive evidence by deponents or witnesses to the contrary. This is what one would normally consider to be a dispute of fact, a simple case of two differing versions. Secondly, the respondent may admit the applicant's affidavit evidence but allege other facts which throw a different light on the applicant's allegations, which fact the applicant disputes. This amounts to the classic confess and avoid scenario dealt with under pleas in the section on pleadings below. It has the effect of placing the evidentiary burden on the respondent. Number 3. The respondent may concede that he has no knowledge of the main facts stated by the applicant, but may deny them, putting applicant to the proof and himself giving or proposing to give evidence to show that the applicant and his deponents are biased and untruthful or otherwise unreliable, and that certain facts upon which applicant and his deponents rely to prove the main facts are untrue. Having explained when a dispute of fact will arise, it is also important for you to know when a dispute of fact will not arise. One way in which a real dispute of fact will not arise is if the respondent simply gives a bare denial of the allegations in the applicant's affidavits. Price said the following in the case of Sofiantini versus Mould, 1956. If by a mere denial in general terms a respondent can defeat or delay an applicant who comes to court on motion, then motion proceedings are worthless, for a respondent can always defeat or delay a petitioner by such a device. It is necessary to make a robust, common-sense approach to a dispute on motion, as otherwise the effective functioning of the court can be hamstrung and circumvented by the most simple and blatant stratagem. The court must not hesitate to decide an issue on affidavit merely because it may be difficult to do so. Justice can be defeated or seriously impeded and delayed by an over-fastidious approach to a dispute raised in affidavits. In the recent case of Reitman Construction versus Head for Proprietary Limited and another 2008, I hope I'm reading that correctly, please forgive me. The court elaborated on the concept of a bare denial as follows. A real, genuine, and bona fide dispute of fact can exist only where the court is satisfied that the party who purports to raise the dispute has, in his affidavit, seriously and unambiguously addressed the fact said to be disputed. There will, of course, be instances where a bare denial meets the requirement because there is no other way open to the disputing party and nothing more can therefore be expected of him. But even that may not be sufficient if the fact averred lies purely within the knowledge of the averring party and no basis is laid for disputing the veracity or accuracy of the averment. When the facts averred are such that the disputing party must necessarily possess knowledge of them and be able to provide an answer or countervailing evidence, if they be not true or accurate, but instead of doing so, rests his case on a bare or ambiguous denial, the court will generally have difficulty in finding that the test is satisfied. I say generally because factual averments seldom stand apart from a broader matrix of circumstances, all of which needs to be borne in mind when arriving at a decision. A litigant may not necessarily recognize or understand the nuances of a bare or general denial, as against a real attempt to grapple with all relevant factual allegations made by the party. But when he signs the answering affidavit, he commits himself to its contents, inadequate as they may be, and will only in exceptional circumstances be permitted to disavow them. The court added that an applicant who seeks final relief on motion must, in the event of conflict, accept the version set up by his opponent unless the latter's allegations are, in the opinion of the court, not such as to raise a real, genuine, or bona fide dispute of fact, or are so far-fetched or clearly untenable that the court is justified in rejecting them merely on the papers. Also, in Plascon Evans Paints Limited versus Van Riebeek Paints Proprietary Limited 1984, the court held that if disputes of fact become apparent on the affidavits, a final order or relief with a final effect may only be granted if the allegations in the applicant's affidavits, which have been admitted by the respondent, considered together with the allegations made by the respondent, justify such an order. In a nutshell, the test the court will apply to decide whether there is a real dispute of fact was stated by Chief Justice Watermeyer in Peterson versus Cuthbert and Co. Ltd. 1945. In every case, the court must examine the alleged disputes of fact and see whether in truth there is a real issue of fact which cannot be satisfactorily determined without the aid of oral evidence.